Hey, we continue to ask the experts right here on News 96.5. You tell your friends if they need to know how to fix an air conditioner, get their car fixed, if they need to know about swimming pools and backyard features, if they need to know about the law, whatever it is, estate and business planning, mortgages, it's all right here on News 96.5. And I'm pleased to welcome back to the microphone Eileen Mazenetz. She is a litigator for the Law 2020 show, and the Law 2020 show, of course, is BCN Law Firm, Boyette, Cummins, and Nalos. They have offices in Winter Park, Claremont, Lakeland, the Villages, and a satellite office for your convenience in Sebring. Oh, that's so cool. BCN Law Firm can be reached anytime at 855-LAW-2020. Eileen's going to sing that for us, right? Like the commercial? You going to do that after? Yeah. Okay, good job. Eileen Mazenetz is with us, 855-LAW-2020, 855-LAW-2020. Now, when she was on here last time, she's a litigator, but we're going to talk about something else today. But any legal question you've got, we'll take a shot at it today at 855-297-9696, 855-297-9696. 9696. The cool thing about that is you don't have to use your real name, and you don't have to say the legal question is about you. You could actually say, my friend Tim has been considering this, or this, whatever it may be. You could also text in, and we won't give your phone number, but you could text in 21232. That's what you put in the recipient line of your texting feature on your smartphone. The address is 21232, which spells out Tim is taking your text right now, and I'll read them on the air. Something like that. Okay? Now, tell us, first of all, what a litigator is, and then we're going to get into the meat of what we want to talk about today.
Well, litigation in general is once a lawsuit is filed, you are in litigation. You have a case name, a case number, and your case is pending before a judge. So what we do as litigators is we either defend your case as a defendant, or we sue whoever we're suing on your behalf.
Really cool. So what are some of the cases that have come across recently without names? Just the gist of them, that might pass your desk.
Recently, we just resolved a matter involving one professional suing another professional for breach of a non-compete agreement, wherein the plaintiff was saying that my client had breached a non-compete by continuing to practice in the same area following the expiration of the non-compete.
Mm-hmm. All right, so that's kind of cool. A few weeks ago, we had on Wade Boyette, and he was talking about service marks, trademarks, copyrights, right, all this sort of thing. And now, especially when you're getting into the Internet, it gets very, very crazy out there, because you may own the Mazenetz company, but I may have that domain that I bought. So it really gets crazy now and that sort of thing. But one of the things we want to talk about is, by way of introduction of what that last case you brought up was, of course, non-competes.
Right.
And a lot of people don't realize that non-competes are not just in the radio business or the TV business, where they're usually geographic in boundaries.
Right.
In other words, John Smith, who works for News 96.5, may sign an agreement, and or let's not use 96.5. Let's say with Big Radio Chicago, and he signs an agreement that he will not do work for any other radio station in the Chicago market for 5 years, should he leave this position. Mm-hmm. Or arguably at the same time, because a lot of people try to get away with that.
Right.
So this is it's a new area for you all, but it is a very interesting area, isn't
it? Absolutely. Generally, the types of non-competes that you see start when someone starts to work for an employer. They generally make you sign a non-compete at that time. And those, they need to be supported by consideration, meaning that you need to be getting something to be giving someone your right to not to compete with them. So in the employment setting, when you start with someone, a non-compete is given to you, and then it's reasonable because what they're giving to you is employment. So That's considered valuable consideration for the non-compete.
Mm-hmm.
They also need to be correct, reasonable in geography and in scope. So you can't say, well, you can't compete with someone for the next 10 years of your life, or you can't compete anywhere within the whole United States following the expiration of the non-compete.
Mm-hmm.
So they need to be reasonable in scope and in geography, and a court is going to consider those on a case-by-case basis.
All right. Now, let's say that someone is trying to get a new job and that employer provides them with a contract which has non-compete language in it. There is no way I would sign that, even though I want to work for that company, until I ran it by an attorney.
Absolutely. They're all different. So your best course of action is to have someone look at it before you sign it. But most employers won't hire you unless you sign the non-compete. So you kind of got to pick your battles. Do you want the job bad enough? But have someone look over it, because it could really put you in a bind if you choose to leave that company at some point in time.
In my view, the company is interested in you to offer you a non-compete. So in your professional knowledge, do you think an employer would balk when somebody says, I just want to run this by my attorney, or would they have more respect for you?
You can't take a month to take a look at it, but if you look at it pretty, within a reasonable amount of time, I don't see why an employer would balk at that. Okay.
And so the timing you would need on something like that, if somebody approaches me and says, I want to hire you with a non-compete, you can't do commercials for any other car dealer in Central Florida, and I said, well, Eileen, I'd really love for you to look this over. Let me email it to you, and we'll worry about paying for it tomorrow.
We can take a look at it the same day.
Really?
You call us, we'll take a look at it, let you know our thoughts, but you obviously make the ultimate decision as to what you want to do.
All right, here you go, 855-297-9696. As the employer or as the employee, you probably have questions about this. What can you put in a non-compete? What flies in Florida, what doesn't? 855-297-9696. Text us at 21232. Eileen Mazinetz is with us. She's from the BCN law firm. You can always reach them at 855-LAW-2020, 855-LAW-2020, or you could just call Eileen right now at 855-297-9696. You can text us at 21232, 21232. What are some of the things that just jump off the page at you as the litigator or the attorney that says, I'm looking at this non-compete and it's sour already?
Some interesting scenarios we've seen is when an employer tries to get the employee to sign a non-compete during the employment when it's already been in existence. The employer has to give you something, like I use the term consideration. They need to offer you some kind of promotion for signing that. I wouldn't recommend to a client to sign a non-compete without getting anything in return, especially when you're already engaged in that course of employment. So a non-compete for nothing is something that you need to be concerned about.
And that's fairly standard in the industry?
It happens sometimes, and I've seen clients that now at the end of the employment, they've signed non-competes during the employment with, getting nothing in return, that are now at the end trying to get out of it. And litigation isn't cheap. I tell everybody that it's not cheap. So it's something that we can talk about once that, if that comes.
So you're working for a company and you're showing yourself to be really, really an asset to the company. Right. And they're going, wow, in the marketplace, this guy could kill us if he went across town and worked for Universal instead of us, Disney or whatever. Who cares what the companies are? And so you should say, okay, if I'm that valuable, I need something in compensation.
Absolutely.
So I don't go across town.
Absolutely.
Well, that's pretty cool. Now, at the same time, do you see that, I can't think of the word, but that you agree not to divulge intellectual secrets or how the business is run?
That's contained in non-competes. You can't, when courts look at how to enforce a non-compete or how to read that non-compete, the court wants to make sure that the business has a legitimate business interest in making sure that that non-compete is enforced. So the employer has to present whether that there's trade secrets that are involved, that there's confidential information, for example, past or current customer lists, that there's the goodwill of the company that needs to be protected, or other things of that nature. So a court is going to look at the fact the employer has to prove a legitimate business interest in order for that non-compete to be enforced.
Very good. You're rolling right along. Casey, we've got about 3 minutes to spend with you. And what is your question?
Yes, sir. I was very much interested in beginning a support group for Governor Walker in his upcoming bid for the presidency in 2016. And I wanted to go about it in the proper way, to contact whatever is equivalent to the Election Law Enforcement Commission to get everything set to actually form an independent group to support his candidacy, if in fact that comes to being.
Wow. I think that's something, is there a legal question to that?
Yeah, is there a question?
Yes, I would like to know, in the state of Florida, what the requirements are to establish a political entity, an independent group to support Governor Walker.
Okay, I would give you two aisles on here. I'm not speaking for BCN Law Firm. I'm speaking for personal experience. One is you'd go to the Election Commission and get all of their information on how you do it. If you want legal representation to look over those documents for you, BCN would be your company. I'd also just look at the fact that each and every state does have a committee already formed for presidential candidates. So you might want to look and see how you can support them. It is 12:19, but just remember, whatever you're out to do, whether it's create a dog park or create a major corporation, or you've got somebody that gave you a summons, or maybe you got pulled over for a DUI last night, well, the BCN Law Firm has many, many lawyers under their roof that are all local, they're all great people, and they have time for you and can help you out. That is bcnlawfirm.com, bcnlawfirm.com, and 855-LAW-2020, 855-LAW-2020. We'll be back. Hey, the name of the show, as we ask our experts, is Law 2020, kind of putting law into focus, if you will. 855-529-2020. You could actually spell it out, 855-LAW-2020. You hear the commercials, you hear that jingle, right? BCN Law Firm, BCN stands for Boyette, Cummins, and Nalos. Eileen Mazinetz is with us. She is a litigator. And today we're talking about non-competes. Have you ever worked in a workplace where there's this contract they hand you and you just sign it without even really reading into it? And then you find out later when you have a better offer or you're leaving the company that all of a sudden you can't work in a geographic area or in a trade for a period of time or a period of miles. That can cause some real problems, can't it, Eileen?
It can. I have a lot of clients that just sign paperwork along with HR when they're starting their employment before they start, and it does happen. People have been bitten in the butt, for lack of a better word,
sure,
when they realize they get a nice letter from their former employer after they've already found a new job saying, can't do it.
Wow. And that's never pleasant, is it? Because I can just imagine, if we had Tim here, our producer, who does a phenomenal job, and we had him on a non-compete, and then he decided that, well, he wants to go work for a radio station in Ocala, and all of a sudden he's having that honeymoon period with the new Ocala boss, and everybody's great, and then here comes the summons or the subpoena.
Absolutely.
That would not ingratiate you in the industry at all.
No, a process server showing up at your door isn't always the best thing you want happening.
That's right. It just rang a bell on my phone. I'm telling you right now. So it really can disturb your career.
Yes, absolutely.
Beyond just a letter or that, you could actually get yourself washed out of a career in a market because people talk to one another.
Yes.
Hey, don't touch that guy because he didn't disclose.
Right.
Wow.
Yeah, it happens.
And also, where do you draw the line, Eileen, on intellectual property, which is usually associated with this? Okay, you work for a real estate firm, and you happen to know that the way that they're getting their homes appraised or the way they're getting their homes sold is by using this method, direct mail, by this. But don't all real estate agencies use direct mail? I mean, where is the line?
If someone comes into a new employment already having a certain expertise or certain area of, amount of experience, an employer at that point can't say, well, you learned that on our watch. If an employee comes in and has to undergo, let's say, 6 months of training how a certain company does something, that can be considered a trade secret or confidential information, which could ultimately end up in a breach of a non-compete agreement lawsuit that person's in. Because if it's something that everybody would know, then that's not confidential information. But if it's something that employee gained, for example, customer list or a method, a certain, I don't know, maybe specific software that company uses.
Yeah, there you go.
But it's really, like I said, what Florida courts, it's common. Everything's on a case-by-case basis. The court doesn't look at it. There's not a set of factors that the court looks at and says, okay, boom, 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 this is a breach of a non-compete. It depends on the type of work involved. It depends on the type of, I guess, customers involved, if there's trade secrets involved, what type of information is being given to the new employee.
Wow. And does it ever come down to customers? Like, let's say that I worked for this real estate company and this guy is a flipper and he used me a lot when I worked for ABC Real Estate. Mm-hmm. And then all of a sudden I leave and I'm across town and that person follows me. Wow.
Again, that's another issue. Let's look at what your agreement says. If you know the requirements and what this specific customer likes, say you know what types of things he likes to buy, say you know everything about him, that could be potentially a relationship that you would not have had without your employment. So
exactly.
Again, a case-by-case analysis is how Florida courts look at it. But yes, that could be a potential breach of a non-compete. If you're taking that customer that only that company has had a relationship with, and that company knows everything about what that customer wants, then yeah, it could be.
Mm-hmm. And oftentimes with an employer, if they're insisting on that non-compete, have you seen that to be a deal breaker where somebody says, no, I'm just not going to tie myself up?
Pre-employment relationship?
Yeah. Mm-hmm.
Yeah, I've seen people not want to do it because, a person doesn't want to be restricted on making a living. So if you want to see if there's an agreement that say maybe 5 years down the line, you might want to leave, you could be restricted from making a living somewhere next to your house. Most non-compete agreements have a specific area. Say most people like to work next to where they live.
Oh, yeah.
And if it's within your geographic zone of where you live, you might not be able to work where you live at some point down the line if you choose to live.
And oftentimes in some industries, and I think of radio and television, which I'm most familiar, is that can be a very, very large area with the advent of the internet, the advent of streaming, and, of course, market size.
Right.
If it says you can't work in the Orlando market, that's a whole lot of miles. I mean, that's a big zone.
Cutting off a lot. And I've seen a lot of non-competes say that you can't work in the area where you did business for this company. So if your company travels a lot, say you travel all of southern Florida or central Florida, then you could be restricted.
Wow. If you have questions of this type, if you're thinking about, getting a job and you've seen this language and you have questions about it, or maybe you're an employer and you want advice as to what language you can put in there and still be within the law in the state of Florida, hey, join the conversation. That's what it's all about. You can call us at 855-297-9696. You could text us at 21232, And don't forget, the BCN Law Firm with offices in Claremont, Winter Park, Lakeland, The Villages, and Sebring are ready to serve you anytime at 855-LAW-2020, 855-LAW-2020. Don't forget, bcnlawfirm.com, bcnlawfirm.com. Eileen Mazinetz is with us today. It's only the second time she's been with us. She should be here more regularly. We will be back right after the news, traffic, and weather. Very good. We are back, and Eileen Mazinetz is with us from BCN Law Firm. Law 2020 is the name of the show. We bring the law into focus for you, and if you have a legal question, we had a caller, and the caller seems to have dropped out, but we do have some text, okay? So we'll jump into those texts right now as you reestablish your phone call, caller, to 855-297-9696, 855-297-9696. You can text us at 21232. This is sort of our long segment. We have about 10 to 12 minutes to spend with you. Okay, this question is general law. How do two people go about initiating and settling a divorce?
Well, you can initiate. There's divorce papers to fill out. We recommend that you do it with a lawyer. And if divorce proceedings need to be, litigated, there we have Brian Monk of our office who handles all the family law for the firm. So that's something that's right up his alley. He's done a ton of these matters. Just feel free to call our office on Monday and he can help you.
I always found it interesting, and I always say this when Brian's on the show with me. I think it's interesting that his specialty is family law and criminal law. Mm-hmm. And I always say, well, let's hope it never gets that far.
It's true.
So would you suggest as an attorney that a couple be represented by the same person?
I wouldn't personally.
I wouldn't.
I wouldn't either.
Yeah, I'm sure there's some people who think going in and it's going to be all amicable and everybody's going to get along.
They probably want to do it the most cost-effective way and maybe split attorney's fees. I don't know how people want to do that, but
Yeesh.
I would have two separate counsel.
Yeah, if you all want to delve into this with an attorney, go ahead and call the law firm. I can give you two numbers for your convenience, 352-394-2103 or 855-LAW-2020, 855-LAW-2020. Okay, here's another one for you. If a tenant leaves without paying the current month's rent and still has months in effect in the lease, can he be sued for the remainder of the lease?
Yes. Very easy, question. Yes. What I would recommend to the landlord is, though, do your best to mitigate those damages. What that means is get another tenant in there if you can. You can, if there's 6 months remaining on the lease and you just leave it empty, hoping to sue someone, a court isn't going to look favorably upon you if you just let it remain empty when you could potentially rent it out and get some of your money back. But yes, you can be sued for breach of contract on that lease.
All right, we do have a question on the non-compete, and then we also have a text about maybe a non-compete later. But Craig, go ahead with your question. You're on the air with Eileen Mazinetz from the BCN law firm right here in Central Florida.
Hi, Eileen.
Hi,
I've
Craig.
got a question about a non-compete I had signed a few years back. Actually, it would be almost 2 years to the end of March. With the company I was with, I signed it when I left there to go to work for another company, which was completely out of what I was doing. And I left for a year, and then that company ran short of funds, so I pretty much ended up out of a job. And I was asked by the same company to come back, and I had never signed another non-compete. And my question is that non-compete, basically it expires March 31st of this year. If I didn't sign a new one when I came back, is that non-compete still valid?
So let me just understand your question, Craig. You signed a non-compete after you left an employer's business?
When I was leaving to go to work for another company that was completely out of what I was doing.
I would have recommended that you didn't sign anything. You're not obligated to sign a non-compete with an employer when you're leaving. You're not. So number one, I would have recommended that you didn't do that. But if you have a non-compete that expires, it doesn't automatically renew. So once your non-compete expires, you're good to go on whatever you want to do.
Okay. So even though I went back to that same company, that non-compete, basically once it expires on the 31st, it's a dead issue?
Yeah, absolutely, unless they make you sign a new one.
Fantastic. That's what I needed to know.
Okay, yeah, absolutely.
All right, thank you very much.
You're welcome. Take care.
Bye-bye.
Well, that's interesting. So you leave and then you come back, and that's very, very interesting. I like that. Because I guess it falls down to HR too, because usually if you leave a company and you've had some seniority and you've got some health and you got some insurance, when you start back again, every time I've seen an instance like that, the employer says, I know you used to work here, but now you start over again.
Yeah.
This many months to get your vacation, this many months to qualify for this.
Right.
So, yeah, you're actually starting over again, aren't you?
You are
with a
starting
new
over.
agreement.
Absolutely. And they could, if you come back, they could at that point make you sign a non-compete that perhaps they never made you sign one the first time you were employed with them.
Mm-hmm.
They might make you do something at this point. Again, it all depends on what you want to do. Do you want the job bad enough to sign a non-compete? But I've had situations wherein an employee wanted to leave their job, and during the I guess the conversation with the employer at that point wanted them to sign a non-compete. You don't need to do that.
All right. Here's where, we've talked on this show about prenuptials and postnuptials. And I would say that when you have a business with your significant other, your wife, your husband, that you would be thinking about that early on in the relationship, not when it happens. That is brought on by this text. The text reads, how about if I practice professionally with my wife, we have 2 separate offices, and we divorce? What are my rights?
Again, I would. That is definitely a family law issue. There's a lot of things involved in family law and divorces. Again, something I would recommend that text or call the office and talk with our family law attorney that deals with those issues. But yes, divorces are sticky. Divorces can be ugly, and divorces involve money. Mm-hmm. When there's businesses involved, Florida is a marital property state where things are divided equally. So. Those are issues that need to be dealt with a family law lawyer.
Would you recommend, if somebody is going to be getting married and they're both in the same business and they say, well, now that we're getting married, let's start our own business, Smith and Smith. Okay. Should they have some agreements already written out when they do that?
100%.
That spell out what's going to happen?
Absolutely. Absolutely.
I mean, even more than a family who just fall in love, and maybe she's in real estate and he's a lawyer. Okay, well, that's going to be a bad enough divorce. But if you're in the same company, assets, and now let's go back to the topic of the show. All right, how about non-competes and intellectual property?
Non-competes between spouses?
Yeah,
that's a very interesting issue.
Would that be
seems
cool?
Like a whole lot of issues. That would be interesting. They could have non-competes with each other.
I bet it comes up. Who gets the company name? Who gets the company's assets? Who gets the trademark? Who gets the websites? I mean, wow, this gets very complicated, doesn't it?
Anything can be drafted in an agreement, though. Whatever the parties can agree on, it can be drafted.
All right, very cool. We've been getting a ton of people that are upset with their tenants lately. Richard, what is your call about? We've got 3 minutes to spend together, my friend.
I have a tenant that is in a home with... He's got 6 kids, and I've been kind of leaning, giving him a break over the holidays and that, but it's getting silly now. He's 4 months behind in his rent. He has not got a job again and has no way to pay. And he said if I will let him sign a note for the money he owes me, and, eventually he'll pay me, I hope. Doubtful, but, that he'd be out by the end of this month and leave the house clean and in good shape. Is that legally binding if he signs it, or is it not?
Well, you've got rights against that tenant right now, regardless of a note that you sign with him. It really depends on what you want to do. Do you want them out? Do you want them, to get their life in order and pay you when they can? It's really what you want to do. At this point, you can evict them because of their failure to comply with the terms of the lease. I'm sure that the lease that you have with them probably has some type of notice requirement. You have to give them 30 days before you evict them, whatever it is. Take a look at the terms of your lease. If you want, we can look at it and guide you from there. But as far as a promissory note is concerned, there's nothing more you have to sign because they already have a lease with you, wherein under the terms of that lease, they owe you money.
Okay, well, if they agree to be out by the 31st and they're not out, if they sign something to that effect, I would still have to go through the eviction process.
Absolutely.
If they don't move out. Is that correct?
Yeah, there's still an underlying lease, so you would have to go through the eviction process.
That was my question. He's just lied to me right along for the last few months. And,
well, you sound like a very patient man. 6 months is a long time.
it has run out.
Absolutely. It would in my book, too.
All right, Richard, if you want to follow up as this goes along, go ahead and make sure you write down this number, because this may get to a point where you'll have to seek legal remedy at 855-LAW-2020, 855-529-2020. That is the offices of BCN Law Firm, offices close to you, whether you're in Sebring, the Villages, Lakeland, Winter Park, or Claremont. There are locations to serve you. And we're going to take a break right now. Dave Wall's got three big things we need to know. Then we're going to come back with your questions and more at 855-297-9696. You can text us at 855-297-9696 is a phone. Text us at 21232. 21232. We'll be back. Hey, welcome back to the show. This is Law 2020, brought to you by your friends in the offices of the BCN Law Firm. You can reach them anytime at bcnlawfirm.com, bcnlawfirm.com. You got to go on that website anyway. It's very informative, very cool website. Offices in Winter Park, Claremont, Lakeland, and the Villages, and a satellite office now in Sebring. And let's clarify on that Villages office, it's in 466 in the Santa Fe office building. So, you know, there's a lot of professionals in that, and it is it's public access. It is not inside a gate. When I say the Villages, a lot of people think, well, how am I going to go to it? It's probably in a gate. Nope. 466, public highway, thoroughfare that goes from Lady Lake to Oxford. There you go. There's two big places. But a lot of people out there are now taking advantage of the knowledge and the experience in Lake County, especially of the BCN Law Firm. Very, very much, and Sumter County and Marion County as well. Just gives you a great office right there. All right, we've got Eileen Mazinet's with us. It's always a fun time. She's a litigator, and she's also specializing now in this whole thing about non-competes. And you might see it on your job offer or something. You've got to follow up on that. I wouldn't sign anything that I didn't have fully explained to me. But here we go with another text. My friend was served an injunction for domestic violence. At that hearing, could he be charged and arrested? Does he need an attorney? Whew.
My answer to that is yes.
Wow.
That's a criminal law area, which I would be disingenuous if I tried to give you information with respect to that. But yes, get an attorney when it involves a criminal law matter like domestic violence.
I mean, being served in a parking lot's one thing. Standing in the courthouse in reach of the law enforcement officer might be a really bad thing.
Yeah, you're an easy target right there.
I would guess. And would you recommend, and I know maybe this is more in Brian's dome, that you all talk to each other. If you were going to go to court for something like that, would you not already have an agreement somewhere with a bail bondsman or an attorney?
Yes.
I mean, right up front?
Get some bail money right away.
I mean, I would have something set up already to not waste that one phone call.
Right. Yeah.
Golly. Because your objectivity should be to get back to work as soon as possible. You lose a job for something like that,
and
right?
You might not get back to work, right?
For a while.
Brian of our office deals with those issues. So again, that's something I would recommend that this person who texted it, call him. I wouldn't go to court myself without a lawyer, even being a lawyer myself.
Man, no, I totally agree. And I tell you what, first thing in the morning, you need to have your friend or you call 855-LAW-2020. Ask for Brian Monk. Brian Monk, 855-LAW-2020. That's where I guess the family relationships that he does and specializes in reaches the criminal level.
Absolutely. He does family and criminal. Sometimes they combine themselves.
In this case, it looks like they did or may not have, but at least the charges are there.
Yeah.
Okay, and let's kind of bring it down to back to the basics. Anybody can be sued, right?
Yes.
I mean, if you think that piece of paper comes to you and it scares you to death, that doesn't necessarily mean that you're not going to prevail in court if you've got a good enough attorney.
Right. There's lots of frivolous lawsuits. People use it as a scare tactic sometimes. But once you get those, the summons and the complaint sent to you by a process server, you've got a limit. At least in the civil litigation arena, you have 20 days to respond. So make sure as soon as you get that, you contact someone immediately, because you don't want to get hit with a default judgment, which means essentially that you are conceding to those allegations and you can have a judgment against you.
And wouldn't it be prudent to actually have the attorney answer that within that so many days? Because you might put the wrong thing on the piece of paper.
Yes, I've seen lots of pro se answers that are more like letters to the judge, which the judge probably doesn't take the time to read that. So you need an attorney to prepare an actual answer asserting defenses on your behalf. So yes.
In this case, 1 minute to go, Eileen, in this case, can the person who brought the frivolous lawsuit, if they lose, can they be forced to pay your attorney fees?
Yeah, in Florida, there's a couple of ways you can get attorney's fees. It has to be provided for in a contract, or it has to be allowed for by statute. So if you have a contract with someone, they're suing you to enforce the terms of that contract, the prevailing party is entitled to the attorney's fees. Same thing, if there's Florida statute that allows the prevailing party to get fees, then the prevailing party is entitled to fees.
That is wonderful. All right. That is Eileen Mazinetz. What I would do if I was you, I'd go on the BCNlawfirm.com and just tell them by email how much you enjoyed having her on the show today. Or you could call them at 855-LAW-2020. That's 855-529-2020. It's the BCN Law Firm, BCN Law Firm, with offices in Claremont, Lakeland, the Villages, Winter Park, and yes, now in Sebring. We're going to go with financial planning next.